Hi, in this video, I will give you a brief and simple explanation of contracts. Let's begin. My name is Dean Rod Vera. I'm a law school dean and a law school professor. Here, I will give a simple explanation of contracts as part of the subject of obligations and contracts. Now, remember, I'm not here to replace your professor, whether it be in university or in law school, but I will give you a simple and better and easy way to understand contracts. I'd like to invite you to see my other videos on obligations. I've posted them here and here, or you may look at the links down below in the description. Let's begin in the world of contracts. What are contracts? You have to imagine that contracts is basically an agreement, meaning two or three people agreed to do something, to give something, or even not to do something. The legal explanation of contracts is that it is the meeting of the minds between two parties whereby one binds himself or herself with respect to the other to give something or to render some service. So, what are contracts? Contracts are basically an agreement between two or more people where one obligates or binds himself, promises to do something or to render some service. It is an agreement. I'll explain later why this has to be between two people and why, sorry to repeat it, it is an agreement. Before you understand the world of contracts, I will first give you the principal characteristics of the contracts. The first characteristic is that it is autonomous, meaning parties may stipulate whatever they want to do, whatever they want to perform, whatever they want to give, the terms and conditions of a contract, just as long as it's not illegal, it's not immoral, or against public policy. And we have a constitutional guarantee that the government will not interfere or impair contracts. Another characteristic of contracts is that there is mutuality between the parties, meaning the performance or validity of the contract is based or dependent upon the parties involved in the contract. It is also mutual in the sense that it's not the whole contract or its performance or validity is not left up to one person. It has to be both, or three, or four. One of the best characteristics of a contract is that it has an obligatory force. Not in the sense that you are obliged to do it or you're forced to do it, that would be slavery. It is that if one enters into a contract, again, he binds himself to perform a service or to give something. Without that obligatory force, people will not understand or not respect agreements. That's why if there's an agreement and there's a dispute, you can actually use the courts to enforce those contracts. You don't have to necessarily go to court at first. You can make a demand letter or just simply put or tell the person who agreed to perform the contract is, hey, we entered an agreement. You have to do what it says in the contract. Without that belief, without that trust that contracts have an obligatory force, then I think the country will fall apart. Business will fall apart. People will not respect each other. People will not believe on the word of somebody. Some contracts, I explained in another video, that some contracts don't have to be written. Some contracts can be verbal, and it could be binding. The last characteristic of a contract is that it has relativity, in the sense that the rights can be transferred to the heirs or to one's assigns, or you can sell your rights in the contract. Meaning if person A contract with person B can sell his rights, what is due to him, to C. It's done all the time, especially in loans. Sometimes when you buy a car from the dealer, what you sign is a loan agreement with the dealership, and then that dealership sells the loan to the bank. Of course, what they tell you is that the loan is actually from the bank. But I'm sure there are agreements between dealerships and banks wherein the dealership owns the loan and sells it to the bank before your first payment. Now that I've given you the characteristics of the contract, I will tell you there are stages or how the contract is created, evolved, and terminated. The first stage is preparation, meaning before somebody writes down the terms and conditions of a contract, they prepare, they negotiate, they talk about the terms, what to do, how much. That must be done, or you can call it the negotiation stage. The next stage in the creation of the contract is perfection. It doesn't mean 100% perfect or there are no flaws. Perfection in the sense means that it is signed and delivered. It is when the contract is created. That's why when the term says the contract is perfected, the two parties have signified their acceptance to the terms and conditions either by signing it or, in that sense, performing one of the terms or conditions of the contract. The last stage of a contract is the consummation, meaning the obligations between the parties have been fulfilled or performed. When that is done, technically the contract is terminated or the contract is over. You don't have to sign a termination agreement because if A performs one thing and B promises to do another thing, once those two parties perform what is incumbent upon them, what are they obligated to do, then the contract is now consummated or finished in a way. Now, for a contract to be valid, there must exist three elements. The lack of one makes the contract either null and void, unenforceable, or does not exist at all. The first element or the first essential element of a contract is consent. Consent is actually in the definition of a contract. It is the meeting of the minds, meaning two people have agreed to put what they wanted to do for each other or what they want to receive from one another in a contract. If you are a law student or studying this subject in college, it is basically consent is when the offer is given and the offer is accepted. The stage where the offer meets the acceptance. That is how consent is signified. So we talked about that consent is one of the elements or essential elements of a contract. And that is defined as the offer is being accepted. Now, the offer itself has its own set of elements. The elements of a valid offer is that it must be definite, complete, and intentional. Without any of those three, the offer is incomplete. What are the elements of an acceptance? The elements of a valid acceptance are that one, it must be unequivocal, and it must be unconditional. So, one of the first elements of a contract is consent, and consent is the acceptance of the offer. So, we already have the elements of the offer and elements of the consent. With consent, there must be two parties. Now, certain parties under the law are not allowed or cannot give consent. Persons who are minors, who have mental difficulties, well, the law considers them either insane or imbecile. Those two are the two factual examples of those who cannot give consent. Naturally, the law also provides certain instances where consent cannot be given, such as people who are intoxicated, or maybe those who have been victims of fraud or mistake. Technically, in those situations, the consent is flawed or vitiated. The second element of a contract is object. The object is what the contract is all about. If it's a sale of a thing, if it's a delivery of a thing, is it the performance of a duty or performance of a service? That is the object of the contract. What the contract is for, what is exchanged in a way. There are a few requisites to the object, and let me list them down. They must be within the commerce of man. They must be licit or not contrary to law or good customs. They must be possible. They must be determinate as to its kind or determinable without the need to enter a new contract. And lastly, it must be transmissible. So, for example, if you're selling a thing, a car, land, or maybe even a camera or a phone, what you're selling is the object of the contract. In that sale contract, the thing that you're selling again must be legal, licit, and within the commerce of man. The last essential element of a contract is the cause. The cause is the reason why the parties entered into the contract. Going back to the example of a sale, let's pretend we're selling a car. The object is the car, the cause is the price, and the reason why. For example, the buyer wants to have a car. The seller has a car and wants to sell it. Those are the cause of the contract. Each party has the cause of the contract. Again, the buyer wants to get a car, the seller wants to get rid of the car. You can say that the cause is the motive behind the contract. So in this video, I've given you the basic elements, the basic structure of a contract. In another video, which I will link up here and down below, I'll give you part 2 of my explanation of contracts. Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.